Why don't we do that? Okay. Thank you very, very much for inviting me and my colleagues to participate in this educational session with you. At the outset, I should say that in a real way, what we're talking about when we're focused on the Office of Attorney General is a nascent office, right? I mean, we literally are just getting off the ground, 5 months into the office. And so, somewhat frustratingly, while we're working really hard, we probably need to come back to see you regularly, every 6 months or so, to update you on, our work projects, particularly in the environmental area. Let me just note that Latifah Williams was one of my competitors for the race of Attorney General. What do they say? You got to keep your good friends close. No, not at all. Latifah ran a great race, and it was really Latifah more than any other candidate in the race who was focused on the important function of our office related to the public interest. And the way Latifah campaigned on that is that the public interest requires the Office of Attorney General to fundamentally be out every day with the public, to understand what the public needs are so as to ensure that the law practice, the law business of the city is in fact acting consistent with the public interest. So very easy for me to ask Latifah to come on in and join the team, particularly in the area of community engagement and outreach. So first time ever, right? Election for Attorney General. First time ever the office is independent. First time ever the office is not directly subordinate to the mayor's office. I must say, I thought that we might have some tension from time to time with the executive office of the mayor. I did not anticipate that we would have an all-out war in the first couple of weeks of the administration. And perhaps I was looking at it the wrong way. I actually have a relationship, a good friendship with Mayor Bowser, and have known her over the years, and certainly have not been with her on all issues, but found her at least to be open and receptive to debate and dialogue. So I was the first one to be surprised when literally on week 2, the battle was engaged. And to be clear, what the battle was about the very function of the office. So here's what happened. As we were going around meeting with various council members and really kind of listing out what we wanted to accomplish, including getting more funds for things like environmental protection, juvenile justice, other things, out of nowhere, the Office of the Mayor came out with a pretty radical legislative proposal. And to understand the legislative proposal, we just really need to just look at the words. And so they came out with this Attorney General Act. And sure enough, the initial preamble talked about, the mighty principles of democracy, checks and balances, separation of powers, transparency, and accountability. So I was reading that. I said, okay, that's cool. We're down with that, right? And then the next paragraph focused not on the Office of Attorney General, but instead the Mayor's Office of Legal Counsel. And it said that the Mayor's Office of Legal Counsel shall herefore, going forward, be responsible for determining legal sufficiency of proposed legislation, regulation, and contracts.
Whoa.
And then it said, the next paragraph, the relationship between the Office of Attorney General and the Executive Office of the Mayor shall be one of attorney-client. Okay, very, very important. And then it proceeded to describe how the Mayor's office might reach out to the Office of Attorney General for advisory opinions from time to time. Okay, but nothing mandating that. And what I found to be shocking, quite honestly, was the absolute omission of what was in the Attorney General statute. Remember what Latifah ran on? The idea that the Attorney General had, a legal obligation to pursue the public interest. That was taken out. And so with all of this language, what clearly some in the Executive Office of the Mayor sought to do was to essentially divorce the office from the public interest, right? Because if you're an attorney and you're governed by an attorney-client privilege, it's like a principal-agent relationship. That basically means that we work for her, for the mayor's office, and for the mayor's office only. And then, of course, the language stripped out many of our core functions and gave those over to the mayor's office of legal counsel, again relegating us to advice, when they needed it, right? So literally, this is what happened in the first couple of weeks and the first 5 months of the battle. My friend Mr. Rice over here is a frequent visitor to my office and other sessions, invited or not. But,
I always feel welcome.
But you absolutely do feel welcome, and you and others really grabbed my attention and said, "Hey, look, buddy, you better gird yourself for this titanic battle, because if you lose this, your office is completely done." And so, while we had other things in mind for the first 5 months, I must tell you that all of our energy and all of our resources were absolutely devoted to really killing the proposed legislation from a very very strong and powerful, and I'd say really smart mayoral team. In terms of getting what they want, winning, they're excellent. They're quite good. At any rate, so what did we do? The routine. We went around and tried as best we could to identify council members who would be supportive of the Office of Attorney General's independence. We certainly got Chairman Mendelson's strong support. Judiciary Chairman McDuffie, I'm happy to hear that he's been here before. McDuffie was extraordinarily supportive of our efforts, and I don't think we would have been victorious without Kenyon McDuffie. But I must say, some of the other council members were playing it pretty close to the vest. Again, because the mayor's office is so strong. At the end of the day, we were very happy and emboldened by the public, because there were at least 2 formal hearings and a couple of other roundtable-like sessions where I must say I wish we could take credit for it. We certainly tried to get the public to come out and be supportive, but it was really an organic movement where folks came out from the community, the most sophisticated advocates, many McMillan Park folks and others, and also people who may not have appeared to be sophisticated. And they were absolutely adamant, right? Public interest is what the OAG must be about. That's why 76% of the citizens of the District of Columbia voted in favor of having this independent office. And so I'm happy to say, I guess this is one of your questions, somewhere in there, what is the state of the battle, the mayor's proposed legislation? Well, it's completely and totally owing to the public that the mayor's team decided, I think smartly, to retract, rescind, take away their proposed legislation. And so, for now, we were able to absolutely, defeat what I think was just a huge overreach. I mean, can you imagine on legal sufficiency questions where, they would take out an independent review and just have, the internal folks do it? I mean, as I argued, to the mayor's team, including her in one-on-one sessions, is that your Office of Attorney General is your insurance policy, because we come in, we review these big contracts, legislation, proposed regulations, and give you honest advice as to whether there's a problem that could negatively impact the city. You want that advice. You don't want that advice to be given to someone who is, knows that their job is owed to the answer you want. And at the end of the day, I just really want to thank all of you and so many other folks in DC who came out and really were supportive of the Office of Attorney General. So for now, that legislation is gone. They took it off the table. And indeed, we actually won some things. We've got many, many more things to go. But what we did win was we won independent procurement authority. So to the extent that the Office of Attorney General, for example, wants to hire an environmental expert, right, to help guide us with respect to our offensive environmental strategy, we can do that. We don't have to go ask the executive whether that's okay. We also have independent HR authority, which is significant. And while we sought to establish a large consumer protection fund like those that many of the states that you have in the PowerPoint, like California, New York, Connecticut, so many other progressive states have, we didn't win in that request for now. Chairman Mendelson, in his wisdom, decided against going with the Consumer Protection Fund, and instead he has created a litigation support fund for us. We're still haggling about how much money is going to be in there, but at least there is, the first step towards a mechanism of our having a fund that would be sourced by proceeds of settlements that we garner against, big companies who do the city wrong. And that fund would allow us to be used in many ways. And in fact, in our Consumer Protection Fund proposal, the initial proposal that we proposed sought no limitations on the use of the fund. We wanted to use the fund to pursue the public interest. And so that would have allowed us to do things in the environmental realm with the fund. So I think that keep your eyes and ears open. We'll bring it back next legislative term and try to make a better case for establishing a consumer protection fund, but unfortunately we did not get that this term. There was discussion about the kind of the organization of the Office of Attorney General, and I don't want to get too internal, but I do want to talk about independence and practice of law. Under the DC Charter and under the Attorney General statute, all law business is to be practiced in DC by the Office of Attorney General. The Counsel was kind of split on how independent it really wanted an Office of Attorney General to be. And so what the Counsel did was it broke up parts of our office, large parts of our office. And so the Counsel sent out about 150 lawyers who formerly were employed within the Office of Attorney General and sent them out as counsel to the agencies. And I think it was Kate who indicated that that's a potential problem and conflict. And indeed, you're right, it is, because those lawyers, some who are here, those lawyers, really must be courageous. Whereas before, when they had the benefit of being protected by being with the Office of Attorney General, they would have gotten more protection with being with an independent Office of Attorney General. Now, those 150 lawyers or so work for the agencies that report up, of course, to the executive. And so I really think that those lawyers are under pressure on a regular basis, to do the right thing according to DC law versus, pissing off your boss. And I think that's an untenable position that we have our lawyers placed in. And my guess is that in 2 years, 3 years, the Counsel will see, kind of the wisdom of the model of other states, and will return those former Office of Attorney Generals who are embedded in the agencies back to the Office of Attorney General.
Which was a change made in 1998, all right? I mean, we had already been in this position.
For a good reason.
Right.
Yeah,
right.
So exactly. So in 1998, wisdom prevailed and said, you know what? The lawyers who are housed and reporting to the various agencies should actually go to the Office of Attorney General so as to ensure that DC lawyers are practicing one law. right? Are doing that from the perspective of the office that is charged to practice law in D.C. There was a problem pre-1998 where federal judges and state court judges in this area would tell you that they would have a lawyer in from DCPS one day taking the legal position, and then the next day they might have a lawyer from the Department of Environment taking just the absolute opposite legal position. That caused a lot of problems and chaos in the courts, and that so many agencies in D.C. were really stripped of their ability to operate, and instead court monitors were placed in to run those agencies. Part of the problem was that the agencies were these independent operations, not really guided by any consistency, certainly not consistency as to law. And so in 1998, decision was made to follow 90% of other states and have all the lawyers report to the Office of Attorney General. For the life of me, I don't know why they determined in 2013 that they needed to go back to a system that was proven to not be effective. At any rate, you should know that the Office of Attorney General does view it as our responsibility as the chief legal officer in the city to make sure that those agency lawyers are trained well, that we interact well with them, and that we all are practicing the same law. I must say that in the last 5 months, because our attention has been diverted, that is an area where we need to improve and work on. There hasn't been enough training, really, and it's a weak spot right now with respect to those agency lawyers kind of being out there, on their own right now. Of course, the mayor has an Office of Legal Counsel that is supposed to be focused on making sure that the agency lawyers are able to practice law in an objective way without political pressure. But I'm not so sure, quite honestly, that it's working like that right now. In fact, I have very serious doubts about whether it's working that way. So, first 5 months, quite honestly, was just a battle for the office and its independence. I'm happy to have that fight over because now we can really, focus on some of the initiatives that we proposed during the campaign. In that regard, I would refer you to our website, and you can certainly call me and Latifah and others. We'll get you our Keys to Justice. Our Keys to Justice focus on a lot of issues, including environmental justice. I'm heartened that my former law partner, Vicki Corman, is here, and I have to give her credit for really being a thought leader in the drafting of some of the ideas that we have with respect to the Anacostia River and other really, really aggressive litigation efforts. I think you'll see that in time now that we're able to focus on doing our jobs. I feel like I've talked a lot about the first 5 months. Let me just highlight a few other initiatives that we focus on, then I can make sure that I touch on the issues that you've got on your PowerPoint. Consumer protection is a huge issue in the District of Columbia as in the other states. And quite honestly, the District of Columbia, because of the way the office has not been independent, the Office of Attorney General kind of stumbled into consumer protection offices opportunities just inadvertently. Didn't really have a plan or a strategy to do that. The Office of Attorney General was instead kind of organized to really be supportive fundamentally of the mayor's agenda. And so right now we have 2 full-time consumer protection lawyers. We're happy that the council agreed to give us, and Mendelson did this was fantastic, additional 4 lawyers who will join our consumer protection office. And you should know that the 4 lawyers who will join after October when we get the additional funding will not only be consumer protection lawyers, but they're going to have to be broad. They're going to have to understand environmental law, law with respect to living wage and other things. We really want those prosecutors to be all about the public interest. So consumer protection is a big deal in our office. We've already done some things in that regard. We resolved a case against the S&P rating service, that had really caused big harm, of course, in the housing market, rating synthetic securities that had no value as being highest rating, and really hurt our finances. We were able to bring back $21.5 million to the city on that. Most recently, we were able to secure a pretty good settlement against a company called Chartwell's, a food services contract company here, and did business with the DC public schools. And candidly, there was an error on both sides. The school system did not do a good job of monitoring and managing that contract. They pretty much abdicated their responsibilities there. There were a couple of really good civil servants in the schools who were focused on this, but the school department as a whole kind of let Chartwell's have a run of their contract. And that resulted in massive cost overruns and additional millions and millions of dollars of costs that DC had to absorb. But last week we settled the case for about $19 million at Chartwell's. It's a controversial settlement because the public school system determined that it would still continue to do business with Chartwell's. There's a contract in place through 2017, and it determined that it could, on the basis of the settlement and additional controls, it's really important to know that there are additional controls in place, would allow for the contract period now to 2017 to be run in a completely different way than it had been run before. I do want to note, in that settlement, we were able to get about $1 million. Chartwell's wanted to make sure that the District of Columbia recognized that it valued its relationship with the city, and it asked me and some others, how can they do that? And I'm using the power of the Attorney General, bully pulpit, I said, well, here's how you might do it. We have a problem in our city with respect to our kids not having enough resources, particularly in certain areas of town, Ward 7 and Ward 8 in particular, where our kids don't have the same kind of academic benefits and resources, after-school programs, literacy programs, mentoring, etc., that other neighborhoods have. And so we were able to get Chartwell's to voluntarily contribute monies. He couldn't tell them what to do. I said, well, since you asked, here's what I would do if I were you, but I can't make you do it. Long and short of it is that about $1 million is going to some real good grassroots not-for-profit organizations who have absolute mission and plan to really throw those resources into the kids who need it the most. So that's kind of a creative way that Attorney General in other states really use the power of the office to satisfy the public interest. We're committed on issues of juvenile justice in a big way. For too long, the Attorney General's office in D.C. has had essentially a zero tolerance policy with respect to decisions on charging kids with offenses, prosecuting kids, and not really, in my view, spending enough time and thought on rehabilitation. And so we're doing a lot of that in our office. I can tell you that in the past 5 years, the Office of Attorney General averaged 3 to 5 diversions a month. That's where your kid comes into the system, and for good reason, you say, you know what, not going to introduce the kid to the criminal justice system. Instead, we're going to place the kid in a community-based program that has real good services, and divert the kid, therefore, away from the routine of arrest and horror stories in the criminal justice system. Well, in 5 months, we have averaged 20 diversions. I'm happy to say that none of the kids so far have come back into the system. So that's really important. And so I'm working very closely with the DYRS. There's a wonderful man, Clinton Yates, who's the head of that. And we're looking to really identify the best service providers for kids, who are putting kids in the right environments where they can actually make better decisions going forward. So that's a big effort of our office. Now I think I should make sure that I answer some questions.
You're doing good.
All right, so let's see. What responsibilities do other AG offices have, and how does it compare to the districts? I think, you know, in a real way, we are still developing our independent office. My jurisdiction, for example, is not as broad as, you know, my friend from New York, Eric Schneiderman, nor is it as broad as Kamala Harris in California. The good news is that, you know, I speak with those folks all the time and get creative ideas from them in terms of their approach with respect to the environment or consumer protection or public safety. What I would like to have is you know, an Office of Civil Rights. We don't have that jurisdiction yet. I think we should. I think your Attorney General should be the law enforcer when it comes to that. And certainly, I would love to do what Schneiderman in New York has done, as well as Ms. Harris in California, with respect to having, you know, a specific defined responsibility in regards to the environment. And I think that's where, working together, we can accomplish that, certainly in legislation going forward. That doesn't mean that my office is impotent in areas of environmental justice. Quite the contrary. As I indicated, working with Vicki, you know, we've got the beginnings of a good game plan on how it is we might advance cleanup efforts in Anacostia and, of course, you know, the Potomac. So that's number 3. What else? What can the Attorney General do to modernize the office, engage on sustainability issues like the other states? I think we touched upon that, and I certainly look forward to working with you. I think what we might do is really develop a working group with the environmental activists, where we can identify certain priorities. I mean, clearly saving McMillan Park is a priority.
Thank you.
And I would really like to, you know, have you come into the office and you know, really identify mutual kind of goals, right, and strategies that we can work on from the perch of the Attorney General's office. And certainly legal sufficiency reviews is one way that you can engage our office. And I think you can engage the office in other ways, including coming up with some creative litigation strategies there. What else there? Okay. Does the Attorney General have the ability to set up a DC Environmental Protection Bureau? I think the answer is, in the absence of a statutory bar, why not? Right? Let them tell us we can't do it. And so, you know, I think that
overreach.
Exactly. What do they say? You don't know where the line is until you go over it. Right? So why don't we do that? And perhaps we can talk just a little bit more as to how we organize this working group on the environment. But I think small groups, 5 or 6, reporting to larger groups, you know, really tend to have a good opportunity to be successful. California, I talked about this. So California, more power to them. And, you know, Attorney General Harris, who's running for the Senate for the United States, she has absolute responsibility. It's a statutory obligation to focus on the public interest with respect to the environment. I think that that's an area where legislatively, you know, we could work together to get some of our friends on the council to pass this. There's going to be opposition, of course, but you would definitely have a supporter in me. I should point out that the Office of Attorney General, for the first time, has the power to propose legislation. So this is another area where, working with you, you know, we can identify ways to, you know, ensure that environmental interest and other important interests are protected by proposing our own legislation. I think what that means is that oftentimes, you know, you don't win, but at least you know who's against you, right? And oftentimes, you know, that's part of the battle there, is to identify who the foes are and then go at them in different ways. Pepco. So there were 2 questions about Pepco that I saw in the correspondence that we had with you. One was about our role with respect to the merger debate And second was, what would I do to ensure that I don't have to recuse myself? I was recused. I had to recuse myself from Pepco, not for individual work I did as a lawyer at Venable for Pepco. I think I billed that client 5 hours in 10 years, and I don't even remember what it was about. But my law firm, the Venable Law Firm, has done work for Pepco in the past, and Vicki referenced an environmental case in which Venable provided pro bono efforts. We were adverse to Pepco in that matter, and we certainly won. I think that's what actually caused them to start hiring the firm more. I'm curious how the corporate players really understand the game. It gets you conflicted when they know that you've actually defeated them in a matter. With respect to the Office of Attorney General, I hope you got a chance to review the report that OAG put out. Let me just touch on the recusal. So I'm recused, so I'm not able to talk about my position officially, right, as a government official on that merger. All I can tell you is that I read the report, saw many iterations of the report, and on a personal level, that report certainly captures my views as a citizen in the District of Columbia. And I think it was pretty hard hitting. It was against the merger at the end of the day, but it had 50, requirements, right? Should the People's Counsel decide to go forward, they should at least lock in these 50 things. And so I think that what the Office of Attorney General did was pretty much on the same level as what Brian Frosch in the state of Maryland has done. And our office is poised to continue to defend its position. And I was happy to see that the mayor did not weigh in favor of. I know that everybody wanted to see what the mayor's viewpoint was. I was concerned that they would weigh in favor of, and so I was actually moderately happy that they decided not to say anything. In fact, what they did say is that the Attorney General's report speaks for the city's position. And so I think that we ended up in a pretty good place there. And of course, you're going to have to continue to keep your eyes and ears open and fight hard on that.